Hey, everybody. Well, we have started a little early. Let me just get everything finished set up here. Hello, Babs. Babs, veterans or family. Shy. K-Mitch. Let me just give some shout outs out here. Shout out to all. Shy. Butterfly Dana. Sandra. Charissa. Carolette. Susan. Patty Ward. K-Mitch. Babs. Denali. Michael. Hey, everybody. As always, I'll be driving. You and my sister are so bad for that. So we are going to be able to see it, you guys. If you see the thumbnail, I got a sneak peek of the courtroom. So what we can expect to see in the courtroom, I've got the feed up and ready to go. So as soon as it starts, we will know. Hello, Mama, sir. Good to see you guys. So the reason why I started a little bit early is because you guys know, for the last few days, I have been trying to give you guys the updates on the Bryan Kohberger filings, right? And something always kept popping off. So we're going to do that now before court starts, and so see what you guys think. Okay, so you guys remember, and again, if you guys haven't subscribed, please hit that subscribe button, hit the notification bell. Please hit that like. 29 likes, 48 people in here. Oh, can't start until we get them likes up. I'm glad you made it too. It's free to do, you guys. There's Crazy Graham. Please smash that like, put your DNA on that button. I swear to God, I will never use that DNA against you. It's free to do. Oh, yeah, we got onto the three Kansas City men that were found deceased in their friend's backyard. So every time I went to get to this, something else popped off there. Thank you, Lady D. Okay, so if you guys remember, let me just find it here. I think it's this one. Crazy Graham, you are now entered. Let me just get to my page here. Crazy Graham, thank you so much for your donation. Your donation also gets you an entry into the Valentine's Day draw. I'm giving away a basket. There's going to be over $100 worth of between chocolate and oracle decks and bracelets and all kinds of things in there, you guys. So each time, if you want to enter more than once, every $10 gets you one entry. So if you put 20, you get 2 entries. And we're going to have that draw live right here, February 14th, so you guys can see it all. Hello, Get. Petunia, hello. Okay, so is this it? Let me just make sure. Oh, yes, here it is. So I'm going to show you guys this stuff. We're going to go over it because I find there's something really fishy going on here. Mom Osser, totally understand you guys. You guys got up until the 14th to enter into it. So even on my videos, anything, if you're a replay crew, there's a super thanks button. There's a little heart below any video where you can give a super thanks. You can enter there too, but only if you can, you guys. I don't want to put anybody in any kind of difficulties. But you can smash that like button. That's free to do. Subscribing is free to do. Okay, so like I said, any video or live or anything from now until February 14th, right up till the time of the draw. Okay, so this is, let me go full screen with this. This is what Bryan Kohberger had filed, okay? This is back on the 12th of January. Comes now, Bryan Kohberger, by and through his attorney, N.C. Taylor, public defender, hereby moves for the court order to unseal the defendant's motion to reconsider orders denying motions to dismiss the indictment and in the alternative for permission to appeal from an interlocutory orders and stay of proceedings filed with the court on 12/21. And the state's objection to this motion that was filed with the court on 1/5. Okay? Hello, Trissa. Sarah Adams. Hello, everybody. I'm sorry if I missed you coming in. So what we've seen is Bryan wanted things to start being unsealed, okay? The pending proceedings brought by the motion, supported by the pleadings, do not meet the language of the rule. The issues for the court to decide the procedural and legal and do not delve into areas covered by the rule. Mr. Kohberger sought sealing of his filing solely based on email communications with the Latah County Prosecutor's Office stating they wanted the filing sealed, right? The deadline for Mr. Kohberger's motion was imminent. Thus, in abundance of caution, the defense filed a motion to seal, okay? So basically what they're saying is, we didn't want to do this, but this is what the prosecutor's office was pushing for. We didn't want to get into a motion beforehand and go through a whole big fight to get this, so we just filed it under seal. But we're letting you know this. Mr. Kohberger moves the court to unseal the proceedings and filings on the basis that these filings and proceedings are not covered within ICAR 32. Mr. Kohberger acknowledges the right of the public to be fully informed. You guys got to hear this, because wait till you see what's happening now. Okay? Mr. Kohberger, look at this. Mr. Kohberger acknowledges the right of the public to be fully informed on the issues. Mr. Kohberger has the right for the rule to apply as it is written rather than disadvantage him with items remaining sealed that are with items, okay? With items remaining sealed, not within the scope. So he's talking about everything in the record, sorry, you guys, that's been sealed, that is not covered under ICAR 32. He wants it all opened up to the public, right? And he believes the public has a right to be fully informed. Isn't that nice of him? Hey, Butterfly Dana. But wait, you guys. You know what's happening now? Since then, we've had all of these filings. Okay? Here's the objection right here to the defendant's motion to unseal. Right here, if you can see my cursor. Request for a closed hearing. The prosecutors are asking for a closed hearing on it. They want it under seal. And that's what's happening, or that's what happened this morning. We are now waiting for the afternoon session to see if we're going to hear anything about that, right? But they also had a hearing on January 23rd at 4:30, which we knew nothing of, okay, because it's under seal. Then, where is it? Everything's been sealed. Because the prosecution here has objected to the defendant's motion to unseal. Okay? And they said that the state has filed this memorandum under seal and as it addresses substantive matters of the grand jury exempt from disclosure under Idaho Code Administrative Rule 32 and the Idaho criminal rules. So everything was sealed, even though the defense says they wanted it unsealed. Now it's desealed again. Who's this from? State Idaho. Based on the state's motion to seal, state's memorandum in support of its objection to the defendant's motion to seal, herein filed and no objection from defense counsel. So they did not object to this being heard and filed under seal. No objection. The court does hereby confirm and order that the state's memorandum in support of its objection to the defendant's motion to seal, exempt from disclosure, are sealed. So everything's sealed again. So now they've got a hearing. This is an order setting sealed hearing on defendant's motion to unseal. So that is what happened, I guess, this morning. Or this is what happened on January 26th, sorry. At 11 a.m., they had a motion about they had a hearing on these motions to seal and the prosecution's objections to unsealing things. That was done on the 26th. We know nothing about it because everything is still under seal. What I do find funny, okay, is there's more. Let me just pull this up. Let me make it a bit bigger. This was filed on January 23rd. Order to seal and redact. This matter before the court on January 3rd, state's motion to seal or redact pursuant to ICAR 32I. The hearing was held via Zoom. Ashley Dennis appeared on the behalf of state. They just go through a bunch of stuff here, right? So this is where the judge sealed the affidavit in support of a search warrant. It's sealed. The search warrant and receipt and inventory is to be redacted. This order will remain in effect until further order of the court. So they're saying, therefore, pursuant to ICAR 32 and all this, the court finds it necessary to seal in part and redact the record related to the search warrants for the following reasons. So search warrants, okay? The hearing was held via Zoom. This was regarding Ashley Jennings appearing on behalf of the state and Ann Taylor. So this is them getting their motion. We've already gone through a lot of this. But what I want to get to is this last part. This is like 25 pages. Okay, hang on. Let's get to the last one here. Because we've gone through almost all of these, you guys. Okay, is it this one? No, this was August 7th. Okay, this is for the Meta. Look at the address, 1601 Willow Road. Okay. Okay, that was them giving them 14 days. Where is it? Where's the warrant? Okay, here's the warrant. Right here. This is what I wanted to get to. Search warrant. This search warrant is dated September 12th, 2023. Now, this was all sealed, so we didn't get to know anything about this. So this is any peace officer authorized to enforce or assist in enforcing any law of the state of Idaho. Lawrence Mowry, having given me proof upon oath this day, showing probable cause, establishing grounds for issuing a search warrant and probable cause to believe property consists of information related to the crime of homicide and or burglary. Instagram accounts, okay? They list Xana, Madison, and Kaylee. Okay? They have multiple accounts on Instagram because you can tell by this could be the Instagram names, and then there's another account over here. All user subscription information to include, so we've seen this, but now it's being sealed. Any anything that came back on this is under seal. So any information that they got back from Instagram is now under seal. That's what that one means. Order to seal and redact. Now this one is Microsoft. Okay. From January 23rd, 2024, order to seal and redact. This matter came before the court on January 3rd, which we didn't hear about, on the state's motion to seal or redact pursuant to ICAR 32I, the hearing that was held via Zoom. Ashley Jennings appeared on behalf of the state. The court reviewed the records, and this is just basically they're regurgitating what was just said in the last one, why they want it sealed. And they're saying that it's hereby ordered that the record herein shall be sealed, disclosed. It shall be disclosed except for the following: the affidavit for the search warrant receipt and inventory, and that this order is going to remain in effect for who knows, God knows what long. This was a search warrant on Meta. So this was a few of them. The Microsoft. So anything that came back from their search warrants from Microsoft, Meta search warrant, TikTok, are confidential and exempt from disclosure. Stipulation to continue. Let's see if they list who this was regarding. This is just regurgitating stuff that was already gone over. I'm just looking for where they put the names of who's they searched. And this is 23 pages, you guys. Okay, so I, Lawrence Mary, duly sworn, state the following information is true. That I'm employed in Moscow Police Department. Affidavit has been a trained and qualified peace officer for 13 years. I obtained a search warrant for Microsoft OneDrive. The warrant was served on 7/25 by LE Portals. Corporal Payne received an email. Corporal Payne downloaded the file and data and provided it. An inventory was prepared for all items received, and the information received was placed into evidence. They're still not telling me who. Oh, here. Receipt and inventory of warrant on the something day. This isn't filled out. This is where they served it. The persons found inside place were, damn it. Okay, so the descriptions of the property that they got back, so any information that they got back that's in here on somebody's IMEI and somebody's OneDrive. This is our resident ID. Or responding ID. Or requested ID. So they could have, I don't know what RES ID is. I think it maybe be the location on the OneDrive of the requested ID. So say they said they wanted all the information on Kaylee's OneDrive. So say that was here, because it's all blacked out here. So if it says here Kaylee's OneDrive, the location is going to be on the OneDrive of the requested ID, which would be whoever this is over here. Okay, so that one's that one. Now this one, this is the one that gets me, you guys. Wait till you see this. Wait till you see this. This was January 23rd. Okay, saying that they want it all sealed. This is just regurgitated again, the same information as in the last ones. Acknowledging who he is and what they did and who represented who, whatever. Word salad. Order continuing temporary seal of search warrants and related documents pending hearing. You see that? You see this, you guys? Order continuing temporary seal of search warrants and related documents pending a hearing. Hopefully some of this maybe comes out. Because look at Based on the stipulation, continues seal. This again is 23 pages. Okay, so this is just regurgitated again. Wait till you see who this is regarding. This is just all the stipulations, what they're agreeing to, what they're not. Sealing. Let's get to this search thing. This is saying they got the return of the warrant, the information that they were looking for, that they got. This is when they filed it. This is when it was served. This is when they got an email directing a download of the information that they were requesting on this one. And then like 5 days later, they downloaded the data and an inventory was prepared for all items received. A copy of the inventory receipt was emailed to something and something. Now, what's something and something? I don't know. But let's see what this is over. Look at this, you guys. This is TikTok. Okay, so far, and we've seen it all. Their Facebooks, all their social medias for Xana, Kaylee, Madison, right? We've seen they wanted all their TikToks. They were trying to make a connection to Bryan Kohberger, right? Do you remember all that stuff, you guys? Hello, Comp2. Welcome. But look at this. Description of property, location of person. They got the phone number. There's a phone number, too, that they had searched. Look at the long list here, right? All of this. It's been redacted. This is not filled out, but watch. Look at, okay? Any peace officer authorizing to enforce or assist enforcing any law of the state. Okay, this is a warrant on Ethan Chapin's TikTok account with any of the following email addresses. So it looks like he has at least 2 email addresses here and the phone number for account information between June. I'm going to go over this and tell you why I think this is important. Between June 1st, 2022 and November 14th, which is the day after their lives were taken, right? Do you guys know why June 1st is an issue for me? Do you guys remember? Anybody? Hey, Summer Dawn. Dana, come to. Does anybody remember? I'm waiting for somebody. No, nobody remembers. If you remember back a couple of videos ago that I did, I said, everybody's looking for a connection to where Bryan Kohberger could have met one of the girls or Ethan. You know, were they friends on Facebook, TikTok, all that? They were looking into it all. But what had came out was, my mind is fried. I was on with my life insurance. Oh boy. Norma, hello. I came up and found that Kaylee celebrated her 21st birthday in Pullman, Washington, June 6th. If you remember in that video, everybody was saying, no, he didn't graduate until late June, early July, so he didn't go to Pullman until July. No. He was in Pullman the beginning of June. What happened was because of, I guess he didn't want to go. I don't know why. He got his certificates and everything early. They give them out in May, and then they have the big celebration in June, the end of June. Bryan didn't go to that. Bryan went to Pullman. So he got his documents and everything from graduating back in Pennsylvania. He got all that in May. And then even his mother made a comment that once he graduated, he left. She was all sad because he'd left the home. He went to Pullman end of May, beginning of June. Okay? Now, where the Cougar bar is, or the Coug bar, is like an eighth of a mile, like a 2-minute drive from where Bryan lived. Okay, maybe 3 minutes, 4 tops, from where Bryan lived in Pullman, Washington. She signed the wall in the Coug. Now, the Coug is a hangout place for Washington State University people. That's where everybody goes. That's the known place to go. It's called the Coug. Something like, what's the name of the one that they all went to, the Idaho, that bar? Like every university college has a specific bar that everybody goes to, whether the bar owners want to be associated that way or not. It's like, it's a fave for everybody that attends college. We got to go to this bar. Well, in Pullman, it's called the Coug. And on January 6th, Kaylee was there celebrating her 21st birthday. She even signed the wall and put her sorority name, the name of her sorority, underneath it, and signed the date and everything and her name. So we know she was there on June 6th. Is that where Bryan Kohberger could have banged into her? I'm not saying that's what happened, but I'm saying it's a huge possibility. And then we found out that there was a pool party that was given in Moscow for Moscow University students through a pool party, and Bryan was invited to that. Were the girls there? Was Ethan there? Was Xana there? Right? So I think now that they are going here, June 1st. That's why I think they are going back to June 1st. That's what I think, you guys. To see if Ethan had ever maybe spoke to him. I don't know. Did he, I don't know. So Ethan's is one, and look at who the other ones are. Dylan Mortensen and Bethany Funk. And they're all from June 1st. See this? June 1st. Because Bryan was in Pullman the end of May, beginning of June. The Corner Club. Thank you, Bubs BB. And hello, Sunshine Princess. Hello. Corner Club. So like the kids from Idaho State University all went to the Corner Club. And then to that grub truck. You know what I mean? Well, in Pullman, they go to this bar called the Coug. I showed it all on one of my last videos. You'd have to go back and look at it. So Kaylee, being from a rival university, she was in their bar. The bar that everybody from Washington State would have, well, not everybody, but you know what I mean. The hip place to go for these college students was called the Coug. And Kaylee celebrated her birthday there. She wrote her name on the wall with the date and her sorority underneath. Is there a connection? Could he have met them there? Was Bethany, Dylan, Xana, sorry, I'm Canadian, French Canadian. We pronounce things differently. I get ripped for that. But anyway, Ethan Chapin, could they have all gone there for Kaylee's birthday? Who knows? We don't know. Everything's under seal. So we don't know why they want this, but they want everything from these TikTok accounts. Everything. The TikTok accounts with any of the following identifiers. Ethan with 2 emails. Dylan Mortensen looks like she has 2 emails. Bethany Funk looks like she has 2 emails. But they want everything. All identifying stuff, contact information, full name, email address, physical address, including city, state, and zip code, date of birth, phone numbers, gender, hometown, occupation, other personal identifiers, all past and current usernames associated with that account, the dates and times at which the account and profile were created, and the internet protocol address at the time of sign up. All activity logs, including IP logs and other documents showing IP addresses. So that means if she had gone and logged into her TikTok from a different IP address, like somebody's house using Wi-Fi, and the date and time. And that's why I said this is going back to June 1st, you guys, and time of each log on to the account. They want everything, all information regarding the particular device or devices used to log in or to access the account, including all device identifier information or cookie information, including all information that particular device or devices used to access the account and the date and time of those accesses. All data, like everything, all communication, all user content, uploaded, shared, doesn't matter. They want everything, photographs, images, location data, geotags, all data that had been even deleted by the user. A list of all the people that the user followed on TikTok and all the people that followed them. A list of all the users that the account unfollowed or blocked. Do you remember us hearing in one of the, I think it could have even been Kaylee's dad that had said that there was messages that Bryan Kohberger sent to one of the girls that went unanswered, and that he had photos of one or more of the girls on his devices that he had saved. I'm going back to that read that I did, you guys, and I'm sticking to it. And I do believe that this is I'll get even with you. And I think that if these people were with Kaylee that night, like if Maddie, Xana, and Ethan were with her that night celebrating, and Dylan and Bethany, and they all like, get away from her, you creep, get away from her, you creep. You know what I mean? He could have targeted them all. I still think that Kaylee was the one that he was focused on, though. Especially Maddie. Maddie would have, get away from her, you creep. You know what I mean? Everything is possible. Well, that's what my read said, that he was basically told, get lost. You know what I mean? Maybe Kaylee ended up blocking him because whoever he sent the text messages or messages, DMs, whatever they call them, they went unanswered. He sent them to one of the girls, and they went unanswered. The girls never answered them. I believe that's what peeved him off. Go back to my beginning reads on this case, you guys. So they want everything. Everything. So that was, I think, the latest filings, you guys. Let's just scroll down just for shits and giggles. I'm anxious. No, there's the... Okay, so there's nothing in the Chad Daybell case yet. And this is just the judge denying John Pryor's motion to withdraw. And they're going to unseal the August 25th order on motion to appoint co-counsel. What's that? I know this is not on topic, you guys, but I just want to... So it looks like the judge is going to unseal some stuff there. Okay, so that is what we have for Bryan Kohberger. These files are so long, you guys. And you notice that when I took that picture, I showed you guys on my live too, that whoever puts this into the record, they had put some of Chad Daybell's orders and motions and everything in here in Bryan Kohberger's stuff. Well, it's been fixed. I did email them and tell them, and it was fixed pretty quickly. Hello, stay-at-home mom detective. Hello. Carol says, "Want to let him join the party?" Yeah, and I'm still saying it's Kaylee. Wanted nothing to do with them. Probably blocked him, and it peeved him off. So I am anxious, you guys, to see what is going to come out today in this hearing that is coming up that we are going to be able to watch right here as soon as it's up. Let me just look over here. Okay, yeah, it's not up yet. Okay. I'm just checking a few things here, you guys. To see when it goes away. So what do you guys think? What do you think is going to happen today? Carolette says, probably a lot more bull pope. Yeah, he couldn't have things his way, right? Yeah, it was weird, Butterfly Dina, because I was looking at it and it's like, what? Because on live, just for shits and giggles, I said, let's go and check and see if there's been any new filings in the Bryan Kohberger before I had gotten off a line, right? And when I went and looked, it's like, what's this? These are Chad Daybell documents filed in Bryan Kohberger. And then I guess the word got around on Twitter and everything about this. And everybody's saying, well, I just went and seen and it's not there like that. Well, I got photos of it that I did post on my community tab. But I also, while I was live, I told you guys, give me a minute. I'm going to email them and let them know that there's been some misfiling here. And like within half an hour, it was changed. It was gone from there, but not before I got a photo of it. Lies, lies, and more lies. Well, that's all we're waiting for right now, you guys, is for this to start. Come on, you guys, smash that like button. We got 63 likes, 84 people in here. Let's go. It's free. And Crazy Graham so far has got an entry into the basket. I guess I could show you guys the basket while we're waiting. Let me just clear my junk. I'm hooked on this diamond painting stuff, you guys. Hooked on it. So let me just clear this a bit and I'll show you. I still haven't got to add anything more to it yet, you guys, because I've been wrapped up in all this Kansas City stuff. go. Whew. It's Oprah. You get lies. You get lies. Everybody gets lies, right? Okay, so here is the basket. Let me just tilt it a bit, you guys, so you can see some of the stuff that's in here. We've got a coffee mug full of chocolates. We've got chocolate roses here. We've got chocolate, what are these? Crispy balls. What are they called? With the Nutella inside, hazelnut flavored filling inside. You know those, what are they called? Yves Rocher, whatever. An oracle deck. It's a good starter deck. Wish, 4-leaf clover necklace. We've got a chakra bracelet and chakra keychain for your 7 chakras. I don't know where to put this. Let's put it there. We've got the gold cross, gold tone and silver cross. Every time I move this, we got the evil eye. This is good luck and protection. The evil eye bracelet. It's a really nice bracelet. We've got the stone wish bracelet. We got rose quartz. Close your eyes and make a wish. Put this bracelet on your wrist. When the bracelet breaks in two, then your wish may come true. So there's one for love, harmony, and happiness. So you put them on, and when they break, that means your wish is about to come true. We also got this little guy. See, I keep losing stuff down in there. Healing stones in this little, and you can take the lid off of this if you wish. Oops, I just broke part of the cork. You can take the cork off and you can put your own little healing stones. This is sandstone that's in here right now. Then you just put the cork back on. You can add some to it. So, and I am going to be adding it. And once I've got everything in here that I want to put in, you guys, I'm going to wrap it. You know how you get all that wrap up in cellophane? And then you're going to have this fancy bow with some frilly stuff all on it. So anytime you guys give crispy balls, yeah, it's like those Yves Rocher. You know those Yves Rocher? I forget what they call them. Those little chocolate things, and they're like kind of like, I don't know. And they got the hazelnut stuff inside. So that's so far in there, you guys. I'm adding a bunch more stuff to it. I'll be showing that on Sunday when we do our live mini read Sunday morning at 11:30 a.m. Eastern. Just trying to find the time to get everything done that I need to get done. My inner fat kid is just going crazy right now. Yeah, so it's, I mean, you guys give super chats and everything, and it's just my way of giving back. So $10 super chat gets you entered, and we have the draw live. I'm writing everybody's name down who gives a super chat between last week and right up till February 14th. And then you will see your names on the wheel, and we will do the live draw right here on February 14th. Okay, we are still waiting. Comptute says he was supposed to graduate Frapp College. Graduate Frapp College. Ferre Roche. Yeah. Thank you, Mamasser. Well, congratulations, Juror 11. 13, Juror 13. Was it Juror 11, Juror 13? I forget. It's been so long. Are you guys ready now for this Chad Daybell trial to start April 1st? We are going to be covering it, you guys. We're going to be showing it every day right here, just like we did with the Letitia Stout case. We will be covering it. I hope you guys are excited. Juror 11, yes. Okay. Caroline, yes. French Canadian. Willow, you said French Canadian. French Canadian. Parlez-vous en français? Yes, congratulations, Shy. Well, this should be starting anytime, you guys. We are waiting for it to start. Let's see. Refresh. Live. Nothing yet. Oh, that's something else we may be finding out today, you guys. That's another thing we may be finding out today, is if this is going to go to trial this summer. So I think there's going to be scheduling order that we're going to see today. I'm hoping that they touch base on whatever the hearing was this morning. Everybody's going nuts over on Twitter. Why hasn't it started? They're late. Well, this is the court system for you, right? They're always late. We can always do this. Is this it? There we go. Let's get rid of that. Let's put this over here. Well, no, I can't see your chat. Let's put it over here. And I can do this. Share screen. Window. There. There. That's what we're waiting for. Can you guys see it? That's what we're waiting for right there. So this is the setup that we should be seeing, you guys. What you want to talk about, you guys? He's had enough stalling, right? Oh, thank you, Shy. Nana! There's Nana. The only one we're missing is Sister. Let me message her. Why isn't Sister in here? Sister! There, I just messaged her. I don't know if she's going to see it. But this is what we're waiting for. Aw, thank you, Sandra. I love you too. I love you guys. I love all of you guys. You guys are the best. Let's go. Okay, so while we're waiting, let's do this then. I'm going to do this. You guys ready? That is my sister. She just got out of urgent care. Now what? Here we go, you guys. You guys ready? There you go. There you go. So Sandra Stevens, Charissa Jane, Mama Sir, Gina Schaefer, and Bev all gifted free memberships. There she is, my fall, sis. What fall? I didn't even know you had fallen. What is it with falling? I fall down the stairs 2 days after my birthday, fracture my tailbone, fracture my 2 ribs. And then my mama's boyfriend falls down the stairs. And now sister. Oh, I'm sorry, Norma. You're very, very welcome, you guys. Oh, do we have movement? Let me see. No, nothing yet. So there's nothing yet, you guys. Yeah, it was almost looking like it was going to load, but it didn't. X-rays were good, though. Just showed arthritis in my lumbar spine. Oh, boy. Hello, Sybil. Welcome. Sandra. Aw. Right back at you. Aw, I'm sorry, Shy. I'll be giving away more throughout February. You fell too and messed up your shoulder. Everybody falling. And right now, you guys, I don't even dare go outside because we've had freezing rain and we still got freezing rain. Everything is froze out there. We got, oh, here we go. Okay. Here we go, you guys. Let me know if you guys can hear it. Press 1 in the chat. You can hear it when we get going here. There he is.
Okay, great. All right, thank you. Let's get on the record, please. Okay, we are on the record. This is the State of Idaho versus Bryan Kohberger, case number CR 29222805. We have Ms. Taylor, Ms. Logston, and Ms. Massa representing Mr. Kohberger. Ms. Mathis is remote. Mr. Kohberger obviously is in his courtroom. The state is represented by Mr. Thompson, Ms. Jennings, who is here also remotely, Mr. Nye, and that was necessary because that was related to the grand jury, which is secret. So that's what that was all about. I'm assuming that you've all seen the amended order governing courthouse and courtroom conduct. We've made some changes, and you probably also know that we are streaming now, and that is on a YouTube channel. If you don't know that, you can go to the Supreme Court, I guess, website, and you can get that channel if you don't have that already. So you don't want to be on a camera, you probably should leave. But generally, we can't see very well farther back in the courtroom. So just so you're aware of that. So today, we are addressing reconsideration of the order denying motion to dismiss the indictment, and that order is focused on the claim of inaccurate instructions to grand jury. Also coupled on that is the potential for permission for appeal for interlocutory order. So, and a stay of proceeding in the case. I think that's all the preliminary. Ms. Taylor.
Mr. Logston will be arguing, Your Honor.
Okay, Mr. Logston.
I'm gonna, I guess, be succinct since we argued almost the very same thing this morning. But in essence, what we're asking the court to do is to give us the court's blessing to take up the issue to the Idaho Supreme Court. I think the court has noted that it's certainly an interesting issue. The Idaho Supreme Court does have a rule that essentially lays out that this is to be done in very rare circumstances, important issues where people may disagree and that may make it more orderly in a particular case. Our argument is that for this case to exist, the indictment needs to be valid. If there's something wrong with the indictment, that's something that certainly should be addressed. We're also concerned about the fact that there is case law that says that if this case goes to trial, issues with the indictment may become essentially mooted by that and would never be answered. And there's relatively little in the way of case law in Idaho in the last 20, 30, 40 years. And so without permission to appeal, we may never get an answer on this. And certainly that's very important to Mr. Kohberger, because whether or not there's a valid indictment in this case is going to decide whether or not he sits here and whether or not a trial should occur, et cetera. One of the major issues is whether or not that's going to have an issue with the timeliness of this case. And my understanding is that's going to be the next argument that comes after this one. And so we believe if a trial is set out as far as we think it ought to be, that an appeal at this point won't disturb where we think a trial should occur in any case. And in any matter, this isn't our attempt to achieve some delay. This is our attempt to make sure that our client is getting due process at every step in this case, and that nothing is being left, no stone left unturned. Thank you, Judge.
Thank you, Mr. Logston. Mr. Nye.
Thank you, Your Honor. I want to start with the rule that was just referenced. It's Idaho Appellate Rule 12, and it governs interlocutory appeals. And the criteria in that rule set out two factors the court is supposed to consider. The first is whether or not there are substantial grounds for difference of opinion. And on this particular issue, as the court stated in its order, the standard of proof for grand juries in Idaho has been consistently probable cause for at least 3 decades. That doesn't sound like substantial grounds for a difference of opinion. And in fact, the defense conceded in their opening brief on this issue that, quote, the whole of modern jurisprudence on this issue is against this novel theory that they've raised. So they haven't met that first factor. The second one asks whether an immediate appeal may materially advance the orderly resolution of the litigation. And I have not yet seen in their briefing or heard in their argument any path forward for them in which winning this appeal materially advances this litigation. I think if we're all being honest with ourselves, a trial in this case is going to happen. And the question is when. And if we send this case up on appeal, even if the defendant wins, the law clearly allows for us to bring the case back. Even if the Idaho Supreme Court goes out on a limb and says, you're right, the standard of proof in a grand jury should be beyond a reasonable doubt, we could use a normal complaint and probable cause hearing in front of a judge. So it would be the same standard yet again, and we would go in a whole circle, basically resetting the case to be where we're at today. We need to get to a trial in this case. And that brings me to my final point. I'll also try and keep this short. There are secondary factors that the Idaho Supreme Court has looked to in addition to that rule, even when those first two factors are met, to decide, is this actually the case that we want to take an interlocutory appeal? And my read of those secondary factors is it's really asking, like, what is the effect of this appeal on the litigation and on the parties and those involved? And I would just like to point out to the courts, under the rules, this is Idaho Appellate Rule 13F, and it's talking about the stay upon permissive appeal. And it says in F sub 2 that the granting of a motion for permission to appeal under Rule 12 by the Supreme Court automatically stays the entire action or proceeding until the appeal is terminated. So at that point, there's no more discretion. It automatically this case hits the pause button. But more than that, Your Honor, it continues and says, and during that time, the district court or administrative agency shall have no power or authority over the action or proceeding. We're not just talking about a stay in the proceedings. We are talking about this court losing its power and authority over this case while the appeal makes its way through the appellate process. That is going to cause significant delay. As we're about to have an argument or a conversation at least about scheduling. And there is a lot that needs to be done before this trial happens. And this court will have no power to address those issues if this case is pending on appeal. Now, in full disclosure, there are some exceptions to that rule, but it's the exact same exceptions that apply to an appeal as of right after judgment. So it's things like you can change the sentence, you can sentence the defendant, you can change bail, things like that. But for discovery, we've had the genetic genealogy issue that's still out there. We're working and making progress on, but pause button on that, pause button on discovery, pause button on change of venue, pause button on motions about experts and who can say what. It would significantly delay this litigation, which brings me to my final point, and that is I don't want to lose sight of the fact of the seriousness of this case. We are talking about a quadruple homicide. Under Idaho's law, not only are those who were killed victims, but every single one of their immediate family members is a victim. And in this state, in Idaho, our victims have a constitutional right to a timely resolution of the litigation. We are already quite a ways out. And the idea that we would hit the pause button and take power away from this court because there is a interesting issue for the Idaho Supreme Court to address is not something that this court or any court should tolerate. It's time for a trial, Your Honor. Thank you.
Thank you, Mr. Nye. Mr. Lawson? Why?
Judge, once again, we believe this to be an important issue and one that is worth getting a glance, at least from a higher court, rather than being tucked away and forgotten in the maelstrom that is to come. As the state undoubtedly knows, trial won't put an end to this case. This case will go on for 28 years if they do actually achieve a conviction. So the idea that somehow we're running towards something and that's going to do anybody any good from their standpoint is, I think, false. What we're trying to do is make sure that the things that occur in this case are done correctly. And if you want to talk about how long things are going to take, get some stuff wrong, and then see how long it all takes. We're asking that the court would give us permission to go and see if the Idaho Supreme Court would be willing to weigh in on this particular subject. Whether or not the case makes its way to trial at some point is, in our mind, just part of what the court has to look at, particularly in a case where the state's decided that it wants to try to kill someone. Thank
you. Excuse me. Well, first of all, this is a reconsideration of the order relating to dismissing the indictment, whether or not the standard for proof on a grand jury is probable cause or beyond reasonable doubt. I don't think we've done anything wrong about that. That decision was put out quite a while ago. It's rooted in well-settled law. And I think it was correct. Supreme Court, I guess, could turn that around, but that is doubtful in my opinion. We went through Idaho Constitution, statutes, case law, criminal laws, and really common sense. So I feel quite confident that that was a correct decision. So that established that it is well established that the standard of proof for indictment in the grand jury is probable cause, not beyond a reasonable doubt, which is the standard for trial. So putting that aside, now we get to this permission to appeal under Rule 12. So, excuse me, let me just get this in front of me. So the criteria for permission to appeal, this is in Rule 12 of the Idaho Appellate Rules. First of all, it's very, very rare in case law for such an appeal going to the Supreme Court. It does happen, but it is rare. And the court has established this criteria. And I'll just read this part of this. The issue needs to involve a controlling question of law as to which there is substantial grounds for difference of opinion. Again, in my opinion, and based in all the law in Idaho that I've found, is that there is not a difference of opinion about what the standard for the grand jury is. So the defense is making that argument. I respect that. I don't agree with that, but that's where this is. I don't see a difference of opinion throughout the state about what the standard is for grand jury determining an indictment. But this also has a second component. And this is something that Mr. Nye really focused on, is which an immediate appeal from the order may materially advance the orderly resolution of the litigation. And I'm very concerned about delay. And I think that if we send this to the Supreme Court, that it's going to add delay. Mr. Logston is correct. I mean, this is a complicated case. It could take a long time, longer than any of us want. But I think that would add additional delay. And as I said, I'm already concerned about that. We're over a year. Could be another year. I'll just let you all know that. Now, even if the Supreme Court takes up this appeal, or I deny it, and I'm going to deny the permissive nature of this. If I deny it, the Supreme Court can still pick up the appeal. That's up to them. But they do look at what the district judge's opinion may have some bearing on that. I hope so. But they could still overturn the orders of this court denying the motions to dismiss the indictment. And they could dismiss the indictment. what would happen then? Okay, is this going to really materially advance the orderly resolution of the litigation? The state could just file it, refile it, as Mr. Knight said. So that's significantly more delay. So there's some other, actually, this is in a case law, Buttle versus Todd, where it's an old case, 1983, but the court also considers other factors, including the impact of the immediate appeal upon the parties, the effect of the delay of proceedings in the district court pending the appeal, the likelihood or possibility of second appeal after judgment is finally entered by the district court, and the case workload of the appellate courts. But it finishes with an appeal must be exceptional, seeking of that appeal. Because the Supreme Court doesn't broaden the appeals, which may be taken as a matter of right under Rule 11. So, in my opinion, I do not find that the criteria is satisfied for a permissive appeal. There's no controlling question of law where there is substantial grounds for difference of opinion. The law is settled as far as I'm concerned, and there's no difference that I'm aware of. I also do not see how the appeal could advance the case. To the contrary, it would stall the process when we really need to move forward. So I'm denying the permission for appeal, but obviously denying the motion to reconsider. And with that, I think we are ready to go to setting a trial, or at least a schedule order. So anything else about this issue before we go to that? Ms. Taylor?
No, Your Honor, thank you.
Mr. Thompson?
No, sir.
You want to go first, Mr. Thompson, about the state's position on scheduling?
Yes, sir. I'd be happy to. And to start, Mr. Lodson said something that I think needs to be addressed. He makes the allegation the state is trying to kill someone here, and frankly, I find that offensive. What the state is trying to do is to enforce the law that our legislature has put in place. It says, in cases such as this, with facts like this, a jury is entitled to decide not only guilt, but potential felony. We are simply trying to fulfill our responsibilities under the law. To characterize it as the state is trying to kill someone, is just simply appealing to raw emotion, and it has no place in this court. We would ask that that not be allowed any further. Now, as to the trial, Ms. Nyer already noted that we have a variety of competing interests here. We have certainly the defendant's right to a speedy trial, which he has waived at this point. There are also interests of the state itself, and I think even more importantly, the victims and the families of the victims in this case to a timely disposition of this case. Granted, this is a complicated case. It is a very serious case, and a lot of effort needs to rightly be put into it to make sure that the case is handled correctly. At the same time, we need to also balance the need to move forward in a constructive, productive fashion. When the state filed our motion asking for a scheduling order and trial date, which was a little bit over a month ago, we proposed the summer of this year. And at that time, at this time right now, we believe that we could be prepared for trial summer of this year. We realize defense has factors and considerations they want you, Your Honor, to take into account, and certainly we want to afford them that opportunity. I will say, though, that, and that we touched on this in our motion, in our request for the scheduling order, that given the nature of this case, if we are going to try this case effectively with minimal unnecessary harm or disruption to our community, it should be done during the summertime. And I say that because Right across the street there is Moscow High School, that shares parking all around the courthouse with everybody else who's going to have an interest in this case and being here. And we've already encountered the conflict between those interests. We can't sustain that for weeks and weeks on end. That's just not fair to the students. It's not fair to the school district. It's not fair to the media. It's not fair to anybody. The other factor is, as your honor knows, we have two universities, part of our community. And during the academic year, we have graduations, we have numerous sporting events and other university-related events that essentially consume every available hotel or motel room within miles. This case is going to involve bringing in people from out of state, numerous witnesses from out of state who will have to be put up in lodge. And we would submit that that's going to be unnecessarily complicated if trial occurs while the universities are in session. So those are the considerations that we have, Your Honor. As I said, we filed this last month at that time, and as we stand here today, we believe that we could be ready for trial this summer. Thank you, sir.
Thank you, Mr. Taylor.
Thank you. Your Honor, I received Mr. Thompson's motion for a scheduling order, and I had the opportunity to meet with him and talk with him and Ms. Jennings about that. So it is no surprise to the prosecution that we do not believe a summer of 2024 trial is realistic in any way. Understanding the state's concerns, if a trial were to happen in Latah County, we would suggest looking at summer of 2025. However, counsel and the court's aware that our intention is to file a motion for change of venue. That hasn't been filed yet because we're not ready to have that heard yet. There's work that has to be done to present to the court and counsel in support of that. So that's just for the court's information. Your Honor, that in the state's scheduling order, it asks the court for various things. And a lot of those we don't have disagreement with. We think they're appropriate. And in fact, they were things that were covered by the court in the court's original scheduling order. As the court and counsel recalls, last fall, we had not made the choice to waive speedy trial. And so the court did a scheduling order at that time. It wasn't but a few days later that we'd had enough time to discuss that. And Mr. Kohberger decided to waive his speedy trial. And the court vacated that order. So I'm familiar with what the court likes to put out there as far as a scheduling order. And I don't think there's a problem with that. I would want to inform the court that I do not believe this is a 6-week trial. I believe this is more like a 12 to 15-week trial. This is, as everybody said today, a very complicated case. And I want to talk a little bit about what drives both our request no sooner than summer of 2025. And I say that with fear, Your Honor. There are a lot of things that we have to still do. I want the court and counsel to know that we haven't sat around waiting for a scheduling conference to begin doing those things. We have been on this case and active and seeking discovery and reviewing discovery, meeting with experts and working the case since the day we were assigned this case. So with that said, there's still plenty to do. And I want to talk a little bit specifically about that. In a case where there is the potential for a death penalty, we're looking at 2 tracks of trial. We're looking at the innocence phase where there's tons of witnesses and a lot of things that happen. And if there is a guilty verdict, we immediately go to a sentencing phase. That's up to the jury what happens there, but both parties have to be ready to proceed forward. So we don't get the luxury of focusing on our case, the state's investigation, our own investigation solely. We focus on that. We are working on that, but we are required to begin our mitigation case. That's what it's called, the penalty case. We are to put on mitigation. We are guided by the ABA standards, American Bar Association standards in capital cases. That's what this is. A death penalty case is a capital case, and we're guided by those standards. And they tell us that as attorneys, we must investigate every aspect of the case in the innocence phase. We must meet with our client regularly, which we do. We must engage in experts and understand the issues that are coming, which we are. The American Bar Association guidelines in capital cases say we must hire a mitigator and there must be a mitigation investigation. We hired a mitigator, probably one of the very first people we contacted. And so that has been ongoing for 13 months almost as well. We have not been sitting back and waiting. Your Honor, in this case, the complexities are that there are special areas of focus. And when we get to trial, counsel for the state will put on experts to educate the jury on specific areas of focus, as will we. And it takes a while to get all of that done. In addition to that, the court knows everything is recorded. There's digital footprints all over the place. And so we have a lot of records that we have to go through. I know that the court has heard about 51 terabytes of information that we've received. And I want to tell you what that means. Miss Massa found a statistic for me, and I want to tell you how much 51 terabytes of data is. And she found that. She was looking at Dropbox.com, and 51 terabytes of our discovery, to put it in perspective, 1 terabyte can hold 250,000 pictures. 1 terabyte, and we have 51 of those. Or 500 hours of high definition video, and we just have 1 of those. So 500 hours times 51, or 6.5 million document pages. And that's equal to 1,300 filing cabinets. And we have 51 terabytes, not just 1. So that's a lot. There's specialized knowledge. There's a lot to go through in this case. We also have another player in the case, and that's the presence of the media. This is a case that has drawn a ton of attention from the media, and it continues to do so, and I don't think that's stopping anytime soon. The impact of that is that we have found that when we want to talk to witnesses, sometimes they don't want anything to do with us. Sometimes they're people that have already talked to the media too much, and so we shouldn't talk to them or bring them into the case. So that's just a complication. We're working through it. We're working around it, but that's something that the court has to be aware of. I want to let the court know that there are over 400 potential witnesses in the innocence phase alone. I personally and my team have talked to less than 10%, well, less than 10% of those witnesses. In the mitigation phase, our mitigation expert has been actively working the case. We've all been working alongside our mitigation expert. There are still well over 100 people left to try to contact and try to interview. And let me back up and explain what we do with mitigation. We are to learn Bryan's life story. We are to go all the way back to before he was born and learn his life story. We have to be prepared to talk about that in different ways. But it's not just a life story. We're required to go 3 generations back on each side, mom and dad. The court can imagine that there are a lot of documents that must be collected and examined and reviewed so that we are aware of things that we would need to present to our jury if we ever got to that phase. We have had a lot of trouble collecting documents. Sometimes it takes a court order to get documents. Sometimes documents are missing. Sometimes they're very old and you have to piece things together. We're working through it, but I want the court to know it takes some time for that as well. There are records yet to be obtained that we need in both sides. There are still experts yet to be hired that we need to find an expert that has the right expertise and will work on the case with us. We do have several, we're working with them, but there are still more that need to be found. And then let's come back to the discovery. I want to talk about some of the difficulties with discovery, and I want everybody to know that I am not disparaging the state when I say this. I'm describing a complication, a challenge, probably one that the state shares. In this case, we began asking for supplemental discovery in February of 2023. We had some initial discovery, and then we started looking at it and asking for other discovery. We are up to our 11th request for discovery, and there's, I think, 250 items total with subparts to that. The state will respond to us. They're not ignoring us. I'm not saying that at all. There's just a lot out there. But this is complicated because the discovery that we receive, the materials, there's videos, there's interviews, there's police reports, there's photographs, 13,000 photographs. that come in, and they are not indexed. So you get a discovery file and there's tons of subfiles, and I believe this is the way the state's getting it too. And I believe this is complicated because we have multiple law enforcement entities that have been working on the case, and I believe they filter discovery through one of the entities and then it gets to the prosecutor. And I think they're hurrying as fast as they can to get the discovery to us. So I think they're giving it to us as they get it. But there's no indexing in it. So you must open each of those files and see what you have. And you might have police reports in sequence, and then you might not. And you might have photographs, but you don't know which officer took them. You can tell where they are, but you don't know which officer, and you don't know what day because the officers were in that residence multiple times. So that's complicated to try to match all of those things up. There are things that we've asked for that have taken, it's just taken a long time. The court knows we've had motions to compel, and we've had some pretty lively debates about what certain things that we should have and certain things that they don't want us to have for other reasons. Those things take time as well. We don't have complete discovery. I don't think the state has complete discovery, but we definitely don't have complete discovery. I'll give you a couple of examples. There is a video that's a really important video, and we early on received some of it, and we are still waiting for the complete of it. The court would know from our 11th discovery request that there's still outstanding portions of that video that we need to have, and I think the state's working through it, trying to match up video and sound together for the completion, the full several days worth of video. But there's not even an estimated day when we'll get that. And that is critical for us to review and hear all of that. So that's an example, Your Honor, that is not us saying we just don't want to go to trial, we just want to drag our feet. That is us saying there are critical things that we don't have. I am very concerned about expert reports. We have a draft of one, the cast report. The court had ordered that we receive the cast report. It's a draft. I don't think the state has it. I don't think they're sitting back on it, but I don't have that yet. And there are completed materials all over the place like that we just don't have. Our team speaks with the prosecution team fairly regularly about these issues. We communicate by text and by email about things like this that are coming up. We've sat down and spoken with them. They're very open to talking to us, but this just isn't a closed deal. There has to be a deadline on discovery. There has to be a target date where that ends. And then there has to be time to make sure that we've read every piece of it, watched all the videos, looked at all of the photographs, and know where they came from. A few months from now is not a sufficient amount of time to do that. There is no possible way I can even read or watch everything I have now or react to things that are still coming in if we're to have a deadline in time for a summer of 2024 trial. There is no possible way that I would be effective in my investigation, in my presentation to a jury, if I don't have the state's expert materials ready to give to my experts and then get them a report to respond to. There is no way that I am effective assistance counsel if I haven't looked at every bit of discovery that's available. Recently, Your Honor, as recently as January 4th, we received discovery that contained over 9,000 tips that law enforcement had obtained. And we've had, this isn't a new issue, I think the court's heard about this before. We've had bits and pieces of tips, and they've come in and we've reviewed them, but the 9,000 new ones we received January 4th, those were closed out in October of 2023. And I don't think the state sat on them. I think that's an example of the process that they close them out so they can give them to us, but they go through other agencies before they get in the prosecutor's hands to give to us. I have to read every one of those 9,000 tips. There are things that matter to us in our innocence phase that have come up and been done, and I have to read them and appreciate them and react to them and see what's there. That's the duty I owe to Bryan. That's his right for effective assistance of counsel to have me do those things. Your Honor, summer of 2024, it's impossible for us to do it. Our team constantly meets, we constantly work. We are on this. This is our priority. Bryan's our priority, but we are not going to be ready in June of 2024. Your Honor, I want to also talk about some of the other deadlines. One of the things in the state's motion for scheduling order had to do with the alibi defense. And as the court remembers, we had made some submissions and we needed more information before we could do anything more complete. We're still in that circumstance. But when the court vacated its scheduling order last fall, that was part of the scheduling order that was vacated. So the state asserts in its scheduling order that our time has expired, and that just can't be because the court didn't carve that out and say, I'm going to vacate everything but this. So we'll need a new date, but I'd ask the court to be really mindful of the other information we need. We need the cast report. We need other information of things that past agents and other specialists with the FBI might have done with cell towers and records. And I don't have all of those yet. I have some. And the state has pointed me to places that they believe I have more that maybe I missed in the discovery, and I'll look at those. But I'm going to need some time to do that. I wanted to let the court know as well, because the court's going to be considering a scheduling deadline for 12B motions. I want us to have a clear picture before we have that deadline. And the clear picture that I'm concerned about is the state's pathway of how Bryan Kohberger comes to their attention and is identified. I've read that PC affidavit over and over and over again, and I'm not sure. Over a year into this case and everything I've read, and I've spoken with our team, we're not sure how the state decides on Bryan Kohberger. I know different pieces, but I don't know where they fit together. And the more work I do, the less I know about how they fit together. And that is critical for us to assess 12B motions. So while the court's doing deadlines for discovery, I need the court to have something with the 12B keyed on when I have full discovery. I also think it would be appropriate for the court to allow windows to file additional motions based on later disclosed materials too. I think we'll just keep getting materials until the court sets a deadline for it to be cut off. Not anybody's fault, just the magnitude of the case. And so I think that would be something appropriate for the court to set as well. I think that covers it.
Thank you. One more question. So
Sure.
I understand this. I mean, I'm aware of amount of disclosures already. But do we need a whole nother year after this summer? I mean, can I help everybody by having tighter deadlines to make things happen faster so that we can get this trial sooner?
That's a tough question. If the state says you have everything, and I believe they could say I have everything they have, but I know there's other things out there. I know it based on responses to discovery. If I had absolutely everything, all their experts' reports, I would still need a period of time to read and understand that. There's not a shortcut for the amount of time that it takes to go through everything. There's just not a shortcut for that. Having a deadline for discovery helps me. It just does. Having a deadline for expert disclosures, that absolutely helps me as well. I have the concerns of discovery that's not yet made available. I have the concerns of the time it takes to review all of the materials. And I have the concerns about the limitations we're finding with people being willing to talk to us, both for the innocence phase and the mitigation phase, should we ever get there. I have significant concerns. We're working on it. If you could say, everything's going to go according to plan, I'm going to give you these deadlines and all of the materials will be in the state's hands so they can give them to you, and the records you need will be given to you when you ask, and the witnesses that you need to speak with won't slam the door in your face. if you could tell me that, then I would say I could be ready by March of 2025. And that's me saying I'm going to spend every possible hour on Mr. Kohberger's case, which I've been doing and which I'm willing to continue to do, and so is the rest of his team. But my problem is that's best case scenario if we don't run into problems and delays getting records or getting people to talk to us. And if the next calls I make on the experts that I don't have yet secured, if they say yes and they're ready to go and have time to take it on, that's best case scenario. I'm nervous telling you I'll be ready by summer of 2025. I'm nervous telling you that.
This is priority for everybody, and I want to be realistic about it. I don't want to set it more than once. I only want to have one trial, one time, so it doesn't come back. We can only predict the future so much. I only have so much power, so I'm relying on counsel deeply. So let's go to Mr. Thompson and see what you have to say about all this. Just getting things ready for trial.
Ms. Taylor is not understating the amount of work that's involved in this case, Judge. I think that's fair to say, and there's more information that continues to be developed. It's kind of like you ask one question, you get an answer, and that leads you to another question. I know that Ms. Taylor and her co-counsel and investigators are encountering that. We are trying to provide things as quickly as we can, and she's right. There are delays with the multiple agencies getting everything together. The tips, for example, were part of a nationwide tip line that needed to be completely shut down before we could get all the tips that were in it. And so that's why it took so long with these 9,000, I didn't count them, but there are thousands and thousands of tips, most of which are out there, but you're right, all of which need to be looked at to see if they have any potential relevance to the case. As I indicated to the court, if we cannot have a trial this summer, then I would say the earliest would be the summer of next year, for the reasons that I've described to the court about the practicalities of carrying on a trial of that duration with the high school, with the universities. We need to be realistic about being sure that we can get our witnesses here. We'll have something to put them. That there won't be undue interruptions in the community that could cause issues with the community's perception of the trial proceedings. I'm not quite sure what else I can offer.
You're making some kind of argument that changing venue, but I know we're not arguing about that.
And I don't think that's going to change anything, Judge. When this case has national, if not international, attention. This spring, I was at Association of Council of Counties board meeting in McCall, and there was more news every morning from Boise on this case than we see up here. Every doggone morning. I have friends in this community who have traveled to Mexico, and they say, people here were from Moscow, and immediately they want to talk about this case. It's not Moscow, it's not Latah County. It's everywhere. So I don't think that a change of venue is going to solve any of these problems. And the state's position on venue is that the case should be held here. It's a Latah County case. We believe that we can select an appropriate panel of jurors from Latah County. We have the tools to work with that we've discussed with Your Honor. In fact, we already have a fairly comprehensive draft juror questionnaire to send out, so that the court and counsel can assess the level of knowledge and the feelings of the potential jury pool. But we think that we at least owe Latah County, the people of Latah County, the attempt to seat a jury here first, and not just rely on, there's been a lot of publicity. There's been a lot of publicity everywhere. The only place I've heard that there wasn't publicity is in Lewis County. Somebody was talking to a court down there, and they happened to mention Kohberger case and said, what are you talking about? So if we want to change venue, I guess we could go to Nez Perce.
Kind of small.
It's kind of small. Lodgings aren't very good as far as a lot of lodging. But I think that is a practical observation on this case. It's not just here. It's not just Moscow. It's not just Lake Charles County.
Thank you, Mr. Thompson. So you're saying, you're looking at this realistically and the amount of information, evidence, non-evidence, that's might be looking at summer of 2025?
I'm saying that could be where we end up, Judge. I am still concerned about the victims and their families. I mean, they have suffered for well over a year now with a lot of uncertainty. And that's painful. It's an everyday reminder. And they need some certainty and they need some closure in a timely fashion. But we know we also have to make sure, as Your Honor just said a few minutes ago, that we only do this case once. That it doesn't come back on appeal, that it doesn't come back for subsequent things saying that somebody made a mistake. We want to do it right. And the factors are in front of Your Honor. I think that you're certainly in a good position to make the best decision.
It's a decision that pulls me in two different.
I appreciate that, Judge.
Yeah. I want to set it right now. I mean, I'd like to get a little closer with discovery and see if we can have that more quickly. I'd like to speed it up if it's possible. I'd really like to do this sooner than later. I mean, maybe in March 2025, which Taylor, that would be a reach. I just want to let it percolate a little bit. I know everybody probably here, including counsel, want a direct, certain date. But when you're talking about a date so long in the future, potentially, maybe we can get to a point where we can move it more quickly. I'm not going to just let it hang for too long, but it's really hard for me right now to set something in 2025, even though that might be just the reality. And I know that there's lots of other issues to be addressed. I know there are going to be a lot of motions. Going to be a lot of motions about the death penalty as well. So it's realizing to think that we have to have a case so far in the future. But if that's what is the right thing for everything to do it correctly, maybe we only have to do it one time. Because we don't want to do this twice. We don't want to do this 3 times. Because no matter what happens, okay, if he's convicted, it's going to be appeal. And that's also a challenge. So my heart goes out to the victims. I can't even imagine the pain, the grief, because you can't really go forward with your life without this hanging over your head. So, sorry. We'll see. All right, so I'm going to contemplate a little bit. It's not like I have to set this within 2 or 3 months, apparently. And I want to do the right thing. Okay. So, does that conclude what we need to talk about today, Mr. Thompson?
believe so, Judge.
Ms. Taylor?
Yes, Your Honor.
Okay, well, thank you all. We are adjourned.
I seen that coming under advisement. He's not going to give his answer right now. He is going to wait. He's going to contemplate. Maybe he's going to set some dates for a discovery to be in and see what happens with that. He did say he had a hard time setting it so far out. And to me, it sounded like he was going to set it for this year. And then he jumps back and he's taking it under advisement. I do think that he's going to try and set some end dates for disclosure, for motions, etc., to see what can be done and how quick. If there's deadlines, I think he might do that before he even makes his ruling on a trial date. Right, Juror 11, what the F just happened? It's like, I don't know. If I was the parents of one of these kids, of one of these kids, I would be losing my mind right now. Like losing my mind. I don't know. What do you guys think? What do you guys think? Yeah, Dirty Clean says I was joking a year ago by saying there may never be a trial. I mean, there's going to be a trial eventually. I just hope that it is this year for the sake of these parents of the victims, for the victims themselves. They deserve justice. Bryan's not a victim. Bryan doesn't need to be treated with kid gloves. And with this, with Ann Taylor, well, I haven't had time to go over this. Well, if you hadn't have been monkey farting around, bringing up 1800s law, like 120-page motions, and researching all this law from way back when that really doesn't matter anymore because precedent's been set for grand juries and for a lot of the things that she was arguing about. Precedent's been already set. Times have evolved since the 1800s, even since 1960, 70, 80. Things have evolved. Precedents have been set. Case law. You can't keep doing stuff like that and then cry foul that you don't have the time to go through the discovery. You should have been going through the discovery and what you needed to go through to prepare for trial instead of trying to monkey fart around to make a name for yourself. And that's like, I think this is going to go down in history. I've never seen anything like it before when she did that. Never. So it's like, they have the discovery. They can't keep crying foul that they don't have it just because they don't know exactly what memory stick that it was sent over in. When you're sent over discovery, there's a list there that says what's in there. It's up to you as a defense. And I'm one of the ones that had to do it. When we were handed discovery, the lawyers handed it off to me and said, okay, we need this, 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 and this. Find it in stacks of 5,000 pages of paperwork. You know what I mean? It's like, if you can't do it and you don't got enough, you hire some more people and stop going back into 1800s law. Spend your time getting ready for trial instead of trying to make a name for yourself, because the name that you just made for yourself, it's not looking good on you. I vote prosecution, get Willow. Call Willow. But I mean, it's common sense. You know what I mean? And I do, at this point, I feel like she brought up, well, I don't want to be considered like ineffective counsel. Well, look at what you've spent your time doing, trying to make a name for yourself. And that's exactly like being that I did, and I mention this a lot, I know, that I worked in the legal field over 30 years here in Canada. I can see when somebody is trying to do a thorough job and when somebody's trying to make a name for themselves. You know what I mean? All eyes are on her. This is a huge case. So to spend your time doing the things that she's doing, knowing she had to know that it wasn't going to stick, the same as this appeal. And what they're going to do now, I'm going to tell you, what Ann Taylor is going to do now is she is going to go to a higher court to have her appeal heard. And you know what's going to happen? It's going to be denied. The grand jury is not beyond all reasonable doubt. That's for a trial. That's for a jury to decide, not the grand jury. The grand jury is probable cause. It's been that way for as long as all of us here have been alive and longer. I don't care what it said in 1800s. It's evolved since then. So it's like, right. She wasting time. Twilight and Dirty Clean says Twilight Zone. I feel like I'm in the Twilight Zone with this defense attorney. She wanted to make a name for herself. She was hoping that she could get the grand jury indictment thrown out based on what she presented, and she would have went down in history. That's what she was hoping for, but the exact opposite happened. She looks like, I don't know. I don't want to say it, but anyway. You know what I mean? Like, how far do you go in your quest? It's just, I mean, I agree. Bryan Kohberger, like I said, I believe 90% they got their guy. I'm still leaving that door open 10% because my mind may change when I hear this trial. I don't think so, but there is, I can't say never. Like in his alibi, non-alibi, I was out driving around, you know, and there's people I just block them on Twitter because I just can't deal with people who are stuck on stupid. Oh, well, it still hasn't been proven that Bryan wasn't the DoorDash driver. Oh my gosh. Law enforcement cleared the DoorDash driver. Authorities have said they've spoken to him. He gave them insight that they needed for timelines, and he was cleared. Oh no, Bryan could still be the DoorDash. If that was true, the restaurants he delivered for, everything would have been all over the internet. Come on. So it's like, get off it. All these conspiracy theorists and these tunnels, and he's a DoorDash. Like, they've got nothing better. Is that all you got? If that's all you got for a defense, you got nothing. And I don't think the defense has much of anything. A lot of people say, well, I can't convict him on what we know, but that's what we know. You can see with your own two eyes, everything has been sealed. There's a gag order, non-dissemination order. It looks like it's a blanket on this whole case, which is really odd also, especially with Bryan Kohberger saying in one of his motions to unseal that it should be open for the public to see, but then everything is under a blanket, this whole case, not just motions here and there. It's a blanket motion, and you can't even talk about this case. You know what I mean? I've never seen that before. I've seen a lot of sealing happen. We've seen it in the Daybell trial, but nothing like this, where every single thing is sealed. Once in a while, we get tossed a bone like what just happened now, and we get to see something. But generally, 99.9% of everything done in this case is under seal. Say hi, wifey. Shy, say hi to the wifey for me. So it's like, why? It doesn't make any sense. And then you want things unsealed, but let's seal them again. Let's have motions under seal. Let's have court hearings under seal. Let's have everything under seal and don't talk about it. That's not an open and transparent justice system. I understand some things do need to be sealed. Absolutely. Aw, well, I'm glad that I made her smile. Aw, that's so sweet. That made me smile, so we made each other smile. Yay. So it's just like, I've never seen it like this before, ever. It's troubling. And the more and more some of these cases that are happening and going on, I'm still flabbergasted over these three Kansas City Chiefs fans. I'm still like trying to wrap my head around that. There's a few other things that have come out in that, but I'll save that for another live. But one of them is Johnson. Let me just see. I'm going to go over it all, but Ricky Johnson, one of his family members came out and said that his coat was left inside. And what else has now come out is, since this fifth person came forward and called Jordan out on his lies, saying, oh no, you were awake at midnight with the other three, and everybody was alive when I left. What happened after that? His lawyer came out and said, oh, well, there was a couple more people there too. You see what I mean? Every time something comes out that contradicts what Jordan has said, they come out with something else to try and walk backwards. So, I mean, we're going to go over more information. There is a few other things too that have come out. We're going to go over that in another live. But it's just mind-boggling. A lot of these cases are just mind-boggling. Dog Mom says, I think the judge should schedule the trial for later this year and say you have until then to get ready. That way both parties have an end date. Right. And they're under the gun. When you put fire under somebody's butt, things get done a lot quicker. Right? And as far as the IGG, I don't think the defense is happy because they didn't get all of the information. They only got a portion. And that was decided by the judge, not the prosecution. The judge decided that after going through all the IGG information. So, you know, and everybody's saying, oh, well, this is their 11th request for disclosure. That's ongoing in any trial like this. And that is just in case something else has come in. They're just giving the prosecution heads up, like, look at, you know, if there's anything new, we want it. And that's just to keep it relevant on record and in the record that they're asking for it. So if something pops off at trial, the prosecution can't say, oh, well, we didn't get a request for that. Or, you know, we didn't think that that was important to you guys because you didn't request it, whatever. It's just to keep things relevant. Especially when you got so many motions and everything that are being filed in this case, you want to keep that relevant. So can't that allow for a mistrial? Can't what allow for a mistrial? The request for discovery? No. That's just, like I said, just because they're requesting it doesn't mean there's something there. They're just saying, hey, look it, if there's anything else that's come up, we want it. That happens in every trial of this magnitude, especially in a death penalty case. You are going to want, every time you get in front of the judge, you're going to request discovery. Just in case. It's just giving everybody a heads up saying, hey, if anything new's come in, we want it. I don't care what it is, we want it. Especially if it's exculpatory, we want it. Saying time's up. Now, the judge can do it within his discretion. As much as the defense is allowed to have time to prepare and make sure they're prepared, the prosecution also has the right to get this through the court system and get justice for the families. Okay, Shy, nice to see you and the wifey. Stay well, both of yous. Stay safe. I love you guys. Shy and wavy and teen wave. I'm waving back. So with that being said, you guys, I'm going to wrap this up. It's 5:18. I haven't had any din yet. So I'm going to make something quick and easy, I guess. And we'll see what happens. We'll see. I'll keep an eye on the court filings to see what the judge decides. He may call another hearing to do a scheduling order, depending on what he decides for a trial date. Yes, no more falling. Oh my gosh, every time I see stairs now, it's like, and it wasn't Shy. It wasn't just like boom, 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 boom down the stairs. I went right up in the air and then boom, come down on my tailbone. It was nasty. Crazy Graham, thank you. And again, your $10 super chat got you an entry into the draw for the Valentine's basket. And I'll be showing more of that basket, you guys. I'll be adding some more stuff. And I'll show that on Sunday morning, 11:30 a.m. Eastern. You guys can come in and get your very own mini read. Yeah, it hurt. It hurt. I'm hoping that it didn't damage my back. It was a lot lower than where my back was already broke. So I'm hoping, I'm going for an MRI on February 5th. Finally. But right now I'm in a brace and everything. So it does help. And I put the heat on it. And thank God we haven't had much snow this winter. So, okay, you guys, I'm going to end it like I always do. Please take care of yourselves. Please stay safe. Always be aware of your surroundings. I want to see you guys here for the next one. I want to see you guys here Sunday morning, 11:30 a.m. Eastern. Come get your own mini read. Just for you. Just for you. From me to you. With that being said, thank you, mods, for being here. You guys rock. Thank you to all of you for coming and watching with me. Someone asked too. Hello, my darling. Love you too, Bad Monkey. Love you guys all. Thank you for coming and participating. Carolette, bye-bye for now. Love you guys to the moon and back. Catch you on the next one.